The appeals process will start with a letter to your insurance company from your attorney, letting them know that the attorney represents you and requesting a significant amount of information, requesting the entire claim file and all the reasons why you were denied long-term disability benefits. At that point, once you identify the main reasons why the insurance company has refused your disability claim, at that point the attorney should go to work in trying to disprove or challenge the information that the insurance company relied on. You can challenge the information that the insurance company relied on by saying that the original information that they relied on was inaccurate, or you can say that it's incomplete. Either way, you have to produce documentation to substantiate why the insurance company's information was wrong or incomplete. You have to supply that information to the insurance company. Your attorney should speak to your doctors. Your attorney should get questionnaires from your doctors and complete an affidavit for you to sign, and look into all of the vocational possibilities that you do have as an individual, whether it is going to work in a different capacity, whether you can work at all, or whether you're limited in certain fields. All of that information needs to be explored and put into an appeal document that we call an appeal letter. And that appeal letter will list every single element of your claim and every single piece of evidence that we're submitting in your claim, and explain why your benefits should be awarded, why the insurance company should change its mind. You have 180 days to complete that process. If you don't complete the process within that 180 days, then your claim might be barred at that point by your insurance policy contract and by the Employee Retirement Income Security Act. So those timelines are very important. After you submit your appeal letter to the insurance company has 45 days to respond to that. Technically, they can ask for another 45 days if they need the additional time to respond. So that's up to 90 days that they have to answer your appeal. And if they deny your appeal again, you usually have two options at that point. One, you can file suit in the federal district court and you can claim that they have abused their discretion in not awarding your disability benefits. Or two, some insurance policies will have a second voluntary appeal. Now, sometimes this voluntary appeal is a waste of time, and other times, depending on what information is included in the denial letter, you might be able to submit that information to a second appeal before going through the great lengths of going to the federal district court and asking a judge to overturn the insurance company's decision. So that is what an appeal process looks like. After you are denied finally by the insurance company and they say ultimately we are not changing our mind under any circumstance, your only option at that point is to file suit, a federal lawsuit in federal district court, and you ask a judge to determine whether the insurance company abused its discretion in granting or denying your long-term disability benefits. That is a long process. This whole deal could take 2 to 3 years, depending on how long the original appeal process takes and depending on how long it takes to get in front of the judge in federal district court. All of that to say it's a long, complicated process with some severe deadlines. If you don't meet them, ultimately you can lose your case.